time, at the relevant point of time, that bench
was there. Lordship has no determination.
had the jurisdiction,
No.
had the determination.
Determination, as of date, determination is there, but since the court is not sitting regularly, Lordship did not. In fact, matter was listed as item number 2 that day. Order was passed in presence of the opposite party. Now, order could not be recorded, and the court officer called me personally that you have to take step before other court. Lordship is not taking up any matter. No second appeal because court is not sitting regularly.
Counsel, let the copy be served upon the other side.
Yes, I've served. I've served. He was there at the time of passing of the order. In fact, what is on 24th, an order was passed giving direction for putting the special messenger cost.
Learned Counsel, this bench will be available on each and every Friday.
My lord, I know, my lord. Only Friday.
Only Friday.
Yes.
Till date, I can say so.
Yes.
So, let it be mentioned on the coming Friday.
Then I have to give
intimating the other side.
Yes, I have
intimating the other side that it will be mentioned on Fridays.
Friday 14th.
14th. It will be mentioned.
Because I have already
let it be mentioned in presence of the other side.
I have always served.
It has been served.
10:30, my lord. 10:30, my lord. For mentioning, my lord, nobody appears normally.
There is no dispute as regards to serving, but for abundant precaution, let it be once again served, intimating that it will be mentioned on 14th at 10:30.
No, my lord. It is mentioned in my notice, my lord. Kindly say, it will mention today at the first sitting of the court, because I know my lord.
I got it. In spite of that, for abundant precaution and preventive measure, let once again be intimated to the other side be intimated that it will be mentioned on 14th at 10:30.
Then I'm keeping so it. Yes, I'm keeping it today, my lord, and I will be serving my lord today itself.
Let this one also be kept.
Yes.
Kept with the petition, and on that day, the second one also be
my lord.
Attached with this one.
My lord.
Yes. Do you have any mentioning?
My lord, the one application for inclusion in the list.
Application in regard to?
With regard to the setting aside of the abatement.
In respect of?
In respect of, my lord, the appeal was, my lord, the
second appeal or
second appeal.
Second appeal. Has it been served upon the other side?
No, my lord, only Mr. Ronit Kumar Rokit has been appearing. But he is not regularly coming to the court. I overheard by intimate to the telephone that he has asked me to mention the matter, then I will appear.
No, Learned Counsel. It is mentioned here that mentioning will be taken up upon prior notice to the other side.
As your lordship. As your, my lord, let it be, I you serve notice. Otherwise, I not moving this application. As we kept it.
It was before this bench.
Before no. This is not the before this bench.
That's why. Let it be mentioned on 14th, and in the meantime, you serve it upon the other side. The Learned Counsel representing the other side. You are for the you're for the appellant or the respondent?
I'm the respondent. But they are not, my lord, taking out the steps in the matter.
According to you, they are not interested.
Yeah, that is the difficulty.
Let it be served. Mentioning that on 14th, it will be mentioned.
Indicating that 14th.
Indicating, yes. Let there be an endorsement to that effect also, that whether they have received it or not. Okay. Yes.
This is the mentioning of civil revisional application. This matter is actually filed before the Honorable Justice Hiranmoy Bhattacharya. The matter, he heard the matter on, as per I recall, on 14th of July. Then my lord raises some queries. So I prayed before my lords that I have to take necessary instruction from the management. Then my lord fixed the matter on 23rd July. After that 23rd July, the matter was not in the list. I again mentioned on 23rd July. Then on 24th July, the matter started running in the list. But it is on the it can't be here due to it's on 300, 200 numbers going on in the list. After that, there was a difficulty as because my lord was only mentioning on Wednesday, and after that there was an instruction that upon further notice from the court, no mentioning will be allowed for upgradation. After that, now recently determination has changed. The matter has delisted, and now the matter is not in the list of the November also. And the matter, commercial court is taking the matter on 12th of November. Next,
This is in respect of
this
what
is
matter?
this is civil revisional application, actually without giving any opportunity of hearing.
In respect of commercial.
Commercial, my lord. Commercial, and without giving any opportunity of hearing, commercial court allowed their applications and directed the petitioner to produce the documents, some documents, before the commercial court on next date. I have here annexed the order also. So, my lord, there is an urgency. If my lord will allow.
As regards to civil revision applications and petitions under Article 227 of the Constitution of India.
Yes.
No, as regards.
Irrespective of any year. But, yes. Yes, my lord. Yes. But my lord, as because if possible, my lord, will today at least we will get an opportunity of hearing. All right.
Item number 1.
Item number 9, 10, 15, 16, 17 is it? Yes, ma'am. Yes, ma'am. At 9 and 10, I'm playing for the passover, my lord. Playing for the password passover, my lord. Passover, my lord. Mr. Haradan Banerjee is coming in the. Is appearing in this matter. He is in the way.
Has he reached the court?
He is shortly coming, my lord.
Huh?
He's shortly coming. His clock said he's coming.
Not
my
yet reached.
lord. Yes.
You are Padi? You
Uh,
representing the
Petitioner, my lord.
appellant.
Yes, ma'am. Appellant.
Next. Keep on going.
And for the respondent, Lordship.
It has not yet started. Hearing has not started.
We cut one minute. To 5. Paper.
From now onwards, this bench will be available on Fridays.
Yes.
And
So, Lord,
from the coming
the appellant doesn't appear.
from the coming Friday,
Yes.
no,
Adjournment. Yes, Lordship. We'll be ready because if the appellant doesn't
because
appear,
this bench will be regular on Fridays.
Lordship. Maybe a date may be fixed, Lordship. If they don't appear, we will give them notice so that, Lordship, a date can be fixed and we want to dispose it of, Lordship.
At the time of second call,
Yes.
Really fast.
Lordship, I am for the respondent, Lordship. I left yours. Paperwork for it.
In each and every matter prior to the commencement of the hearing, be kind enough to go through the entire record, including the documents.
Lordship, we shall. তা দেখতে হবে সব কমপ্লিট তোর রেকর্ড আছে কিনা।
কিন্তু রেসপন্ডেন্ট আপনি ফার্স্ট কলটা করুন, ঠিক আছে? সাইড অ্যাপিয়ার হলে তখনই হিয়ারিংটা হবে, কলে মানে অর্ডার হবে।
Lordship, in this matter, I'm for the appellant, Lordship, led by Mr. Ashish Chandra Bakshi, Senior Advocate. So, Lordship, if the other side comes, Lordship, kindly fixes a date, Lordship, so that it can be heard out.
The matter can be taken up today itself.
No, Mr. Bakshi is not regular, Lordship, now. So, if a date is fixed, Lordship, it can be heard out on that day. Lordship, in the second call, if the other side appears, Lordship, then.
My lord, 15 I am led by Mr. Haradhan Banerjee, my lord. This is items 15, 16 and 70 pass over, my lord. Yes, 15, 16 and 70.
9.
Grateful.
It is being passed over only.
Item number 19.
রেকর্ড আছে তো? রেকর্ড আছে তো? রেকর্ড আছে তো? ঠিক আছে। Next.
Item number 21.
For the respondent, but it is not hearing matter. In fact, the application. It should.
It is not under the
No,
hearing.
it is not a hearing matter. Appeal has not yet been admitted under order for term.
Huh?
There is a section 5 application.
Section 5 application.
There are now the substitution application.
How many?
Section 5.
How many substitution applications?
One substitution application, one sitting aside abatement, and one condonation of delay. And another application is for under section 5 for condonation of delay in preparing the appeal. So it is not ready for hearing.
You are for the respondent.
And for the respondent. So
In respect of substitution, how many days delay?
about more than 3 years
More than 3 years. In respect of substitution.
in respect of substitution. Let the matter appear under the hearing application. On
The
right.
order will be passed after the second call, at the time of second call. You are for the respondent.
Yes, sir.
Item number 22. Item number 23.
My lord, in item number 23, Mr. Sukanta Chakraborty is appearing on behalf of the appellant. He is engaged in another court, my lord. I'm praying for not today.
Item number 23, I am for the pro forma respondent, Your Lordship. 1 year has elapsed. Till now, no copies have been served on me. Repeated reminders have been given on them, but no copies have been served on me, Your Lordship.
Has the performer in the trial court and the first appellate court, you were? In the trial court, you were?
Anjana Thomas, Your Lordship. I am the
Performer defendant.
Yes.
pro forma defendant. Yes,
Performer
Your-
defendant in the trial court.
yes, Your Lordship. Pro forma defendant.
Did you appear
Yes.
Yes, yes, Your Lordship.
in the first appellate court?
He appeared.
Appellate counsel. Why not served?
My lord, I'm not briefed in this matter. My lord, will kindly takes it up next week, my lord.
Lordship, kindly give the direction, Your Lordship. 1 year has elapsed.
When the matter will be taken up during the next week? Prior to that, the respondent is not here. Prior to that, at least copy be served.
My lord, my lord.
Much obliged, Your Lord.
But at the time of second call, the order will be passed.
My lord, I'm grateful.
Obliged.
Next.
Item number 24.
My lords, in this matter, Dr. Rudraprasad Motilal is appearing for the respondents. He's not keeping well. So, my lords, it's humbly prayed that it's not taken, not today.
At the time of second call, you mentioned.
Okay. Grateful, my
Submit the
lords.
same.
Item number 25.
27. Okay.
Item number 27.
28.
Item number 28.
Name, second call.
Item number 1.
On behalf of Mr. Gopal Chandra Bose, my lord, I am praying not to. Yes, try to, my lord. That is Monday. That is,
Each and every Friday,
yes.
no adjournment will be granted on whatsoever ground.
Extreme circumstances only are.
Provisos cannot be stated at this juncture. You are for the appellant.
Yes.
Give your name.
Usanta Kumar Banerjee.
Learned counsel, Mr. Rohit. Submits, seeks an accommodation on the ground of senior advocate, Mr. Gopal Chandra Ghosh. Gopal Chandra Ghosh. Do not give his name. Give your name only, not your senior's name.
Gopal Chandra Ghosh.
Do not write there the name of your senior. On his ground, you are seeking adjournment, accommodation.
Only on.
ঠিক আছে, শুধুমাত্র ওনার নামটা দেবেন, ঠিক আছে? The learned counsel seeks an accommodation for this day. Full stop. Let this matter appear on the next date. On 14th of November. পরে শুক্রবার। আচ্ছা, এই যে যেটা বললাম না 18, 20 আর 26, এই তিনটে কিন্তু আগে হবে। তারপরে হ্যাঁ, তারপর এগুলো
আসেনি এখনো আসেনি, পৌঁছেনি।
Next, second.
Item number 2.
None is representing either the appellant or the respondents. None is representing either for the appellant or the respondents. Full stop. Let this matter appear on 14.
Number 3.
Same order. S2, item number 2.
Item number 4.
এখানে petitioner respondents হয়ে যাবে, same order as 2 and 3.
Item number 5.
For the Howrah Municipal Corporation.
But in this case, what happens when a petitioner is not appearing, but petitioner died actually.
Record.
So far as I am informed, the petitioner has died, but he is not appearing.
On the last 2 occasions, none represented the petitioner.
I don't know whether they are lost in it, but why not we fix another day? It is up to your lordships.
The learned counsel has representing the petitioner has the duty to intimate.
Right. And it is not a regular bench, possibly. It is not a regular bench, but possibly he is
It
not
is,
appearing
now it is a regular bench on Fridays.
on Friday.
And as such, no further adjournments will be granted.
As your lordship. So let it be dismissed, otherwise let them recall them. If your lordship so
It is
desires.
being done so today. But from the next day,
As your lordship.
consequences will follow.
As your-
On the last occasion, more than a year ago, it was intimated that exception to the report filed on behalf of the Howrah Municipal Corporation has not yet been prepared. As such, he had prayed for extension of time. The Howrah Municipal Corporation is being represented, but none is representing either the petitioner or the 5 and 6 are private respondents.
5 and 6 is the private response.
Neither is representing either the petitioner or the private respondents, that is the respondents number 5 and 6. Full stop. on the earlier two occasions, that is on 2/12/2024 and 12/12/2024, the petitioner was not being represented. Full stop. Paragraph. For the ends of justice, matter is being fixed on 14th of November 2025. Full stop. On that day, if the petitioner is not being represented, consequences, a necessary order will be passed.
Grateful, grateful. 14th of November.
14th of November, next Friday.
Item number 6. My lord, I am for the state. If my lord goes to the record, the petitioner rarely appears.
State is being represented. Full stop. Paragraph. None is representing the petitioner. Full stop. On the last three occasions, none, three, no, 4 occasions, that is on 24/6/2025. Last thing on the group. 13/2/2025, 25/2/2025, 8/5/2025, and 24/6/2025. None had represented the petitioner. Full stop. Last opportunity is being granted to the petitioner. Full stop. The matter will appear on 14th of November 2025. Full stop. On that day, if none represents the petitioner, the necessary order will be passed.
Grateful. Item number 7.
None is representing either the petitioner or the respondents. Okay. Next.
Item number 8.
Same order. Neither represents the petitioner or the respondents.
Item number
9. Done.
My lord, I'm led by Mr. Haradhan Banerjee, appearing on behalf of the respondent, my lord. I'm praying for the not today only, my lord. No, 9 and
The
10.
respondent.
Yes, my lord.
None, the none is representing the appellants. Full stop. Paragraph. Give your name.
Yes, ma'am.
Only your name,
Yes, my lord.
Mr. Representing the. You are representing all the respondents.
Yes, my lord.
Representing the respondents. Seeks an accommodation on the ground of a senior for this day. Full stop. Let the matter appear on 14th.
Can we do it?
Item number 11. I'm appearing for respondent number 225.
And I am appearing for
Learned counsel, do you intend to have a parallel hearing? If your intention is that, we can carry on. Kindly be seated. Then record.
Lordship, Mr. Onimesh Das is appearing for the appellant.
টিন বক্স আছে তো? টিন বক্স কি বলে লক এন্ড কি? Representing respondents number 2 to 5.
Yes,
2,
Lord.
3, 4, and 5.
Yes.
Trial court record and the record of the first appellate court are there. দেখুন ট্রায়াল কোর্টের রেকর্ডটা এবং ফার্স্ট অ্যাপেলেট কোর্টের রেকর্ডটা আছে কিনা, কারণ অর্ডার নাম্বার অর্ডার ডেটেড 1/5/24 এ বলা আছে ট্রায়াল কোর্টের রেকর্ড এবং ফার্স্ট অ্যাপেলেট কোর্টের রেকর্ড নেই এবং পেপার বুকও নেই। দেখে নিন আছে কিনা। You have received a paper book.
Yes, paper book is ready. Lordship, some pages were missing, Lordship, from the lower court records. Lordship will
From the
lower court's record arrived, Lordship, on 21st of April 2021. Yes.
From the order dated 1st of May 2024, it
Yes.
transpires that as the record of the trial court and the first appellate court and the paper book are not in the file.
Yes, Lordship directed them to tag the department to tag with the main file. But Lordship, lower court records arrived in this court. But Lordship, except file D, which comprises of Hazira, all the other papers were there. So Lordship,
Except Hazira's.
yes, not required. So Lordship, it is complete.
It is first appellate court. Title appeal was 238 of 2009.
Yes, Lordship.
Title suit 22 of 2005.
Lordship.
কি বলে এর সাথে তিনটে টিন বক্স আছে, তিনটে সব লক এন্ড কি তো চাবি টাবি আছে। Lord Counsel, kindly go through the documents.
Lordship, we shall.
তাহলে ওনাকে দেখিয়ে দেবেন, ঠিক আছে? আর পেপার বুক আছে, ঠিক আছে নিন।
আরে ডলি সিং এর এলসিআর ছিল, ডিরেকশন ছিল মনে হয়।
Suit for
Lordship, we filed a suit for declaration and partition, Lordship. It was decreed, preliminary decree was passed. Challenging that, Lordship, the appellant preferred an appeal, appeal dismissed.
Sure.
Challenging that, they preferred the second appeal, it was admitted, Lordship.
the respondent's number 2 to 5.
And she's appearing for what?
Corner number 1.
The respondent number 1, and the respondent's number 2 to 5. Okay, only staff. Unique staff. At that relevant point of time, the record of the trial court, the first appellate court, and the paper book was not in the file. As such, there was a direction to trace and tag the same. Full stop. Full stop. On perusal of the record, it transpires that the trial court record, the first appellate court record, and the paper book have been tagged with the file. Full stop. Along with 3 tin boxes. Tin box. In paragraph, in such circumstance, the matter is ready for hearing, but it could not be taken up because of the absence of learned counsel representing the appellant. Let the matter appear on 14th of November 2025.
Lordship, in the meantime, we will serve notice upon them. Kindly
It will
record
be
it.
better.
Kindly record it, give us direction, Lordship, we shall. Let
Direction
there be a
to
direction.
the
Lordship.
respondent.
Yeah, no, upon us to give them notice. Well, let that be there.
Because your interest is involved, as has been sought for by the learned counsel representing the respondent. The respondent is The learned counsel representing the respondent is requested to serve notice upon the learned counsel representing the appellant and the unrepresented respondents for this day, unrepresented respondents for this day, intimating that the matter will be taken up on 14th of November 2025. Next.
I was opposing the appeal on behalf of respondent numbers 1 and 2. Milord, this is judgment of affirmation. Milord, suit for declaration that Milord, we are the owner, and also declaration to the effect that Milord, a deed of conveyance, Milord, is void. Because Milord, I am a Pardhanashin lady. Milord, my LTI was obtained, Milord, on a deed of conveyance. Milord, I shot for a declaration that Milord, that was Milord by exercise of coercion, undue influence, and etc. Milord, my brother-in-law, after death of my husband, Milord, got my.
So, as regards to LTI, you are not challenging. It
Yes,
is
I have
your LTI.
Milord, no, I have not challenged that. I have said that, Milord,
But as regards to the
misrepresentation. I
misrepresentation,
being a Pardhanashin
something else
yes.
stated to you.
I was told that this is a power of attorney. Since my husband has died, I cannot manage the property. My brother-in-law.
In the guise of that, what had
the property was conveyed. So, Milord, I challenged that, and I had a minor daughter also. Milord, the minor daughter's signature was also obtained through me, Milord, projecting me as the guardian. So, Milord, minor daughter, Milord, after attaining majority, challenged that. I also challenged that. Milord, we succeeded in the suit. In the suit, Milord, it was
within 3 years of attaining majority.
Yes. Milord, there is no dispute with regard to that. Now, Milord, suit we succeeded, and the learned trial court, Milord, was pleased to hold in the decree that, Milord, we have title and possession, both.
Possession also.
Milord, possession was not made over, Milord, to the alleged, Milord, purchaser. Now, Milord, they preferred an appeal. Milord, in the appeal also, Milord, it was held that, Milord, we are in possession. After that, Milord, second appeal was preferred. It was moved, Milord, possibly ex parte. And Milord, a status quo order was obtained saying that they are in the possession and that status to be maintained. Milord, we are suffering that interim order since, Milord, the second appeal being filed.
Order dated
8th September 2022. Kindly, Milord, turn to the second page of that order, 8th September 2022. Managers, kindly got the order, Milord? The order by which, Milord, the second appeal was admitted.
order book na alada একটা করতে
May, Milord,
হবে।
hand up. I have a server.
order bookটা সেপারেট করবেন বুঝেছেন। Hmm. 8th of September 2022.
Kindly, Milord,
Substantial questions of
law frame.
Free.
Yes. Then, Milord, kindly take the second page, last paragraph.
In the meantime, till 16th September 2022 or until further orders, the status quo regarding possession by the parties be maintained.
Kindly turn over.
You are in possession.
Now, Milord, kindly turn over the page.
Status quo of now as submitted by the learned counsel of the appellants on instruction is that the appellants.
Now, Milord, kindly take the paper book.
Paper book.
Kindly turn to page 45. Milord, the ordering portion of the first appellate court bill.
No. First, the trial court.
But kindly have a look. Milord, I need not trouble your lordship. I will definitely show your lordship. 45, Milord, the ordering portion of the learned appellate court bill. Milord, last paragraph. The learned trial court, my lord, was, Milord, intending to look at the trial court's order is quoted here. The learned trial court was correct in holding that the plaintiffs had right, title, interest, and possession over the suit properties. Then my lord, kindly come back now to page 32.
Learned Counsel,
Yes, my lord.
right title, interest, and possession
Yes.
over the core and core
Or
schedule,
Those are the suit properties.
suit properties,
Kindly turn to
And-
the next page, my lord.
and
Kindly
that
take-
the impugned deed of sale dated 31/5/1965,
Yes.
that is the core schedule suit.
Yes. Is void vitiated. Kindly turn over the page, my lord.
Interfering with the peace.
It was them, my lord, who was restrained from interfering with my possession.
Therefore, there is no reason for mercy to interfere with the judgment and decree.
Now, my lord, kindly come back to page 32 once. Kindly see what their version was before the learned first appellate court below with regard to possession. My lord, I will not, my lord, ask for any order for vacating the interim order in their absence. Page 32, my lord, second paragraph.
Page 32.
Yes, my lord, second paragraph.
Hmm.
Around, my lord, sixth line, my lord, from the bottom of second paragraph. The sentence starts with moreover.
Hmm.
That was their version. Moreover, according to the learned advocate, the possession of the plaintiffs, meaning the my lord, us, in the suit property was not proved by cogent or documentary evidence. Not his case that he is in possession. He said that I could not prove my possession. Kindly, my lord, turn over the page then. So that was the highest case, my lord, that they ran. That we could not prove our possession. Something, my lord, in the negative. Not an assertive sentence that they are in the possession. Then kindly turn to the next page, my lord. My lord, second last paragraph. That the possession is still with the plaintiffs and that has been admitted by DW1, their witness in his cross-examination. So, my lord, that, my lord, ends the matter. But, my lord, I need to show this, my lord, in presence of my learned friend. I do not want to, my lord, fetch an order from your lordship in his absence. But, my lord, is enjoying this judgment of affirmation. My lord, they suffered a defeat before both the courts below. Now, my lord, is prolonging this appeal.
Apart from 1 and 2, there are other respondents also.
Yes, my lord, Mr. Partha Pratim Roy was appearing for them. He is, my lord, supporting me, my lord. We are on the same page. Partha Roy?
From representing respondents number 3, 4, 5, 7, 8, 9,
Yes.
10, and 11.
Because 6 has passed away.
Achha.
And there was an application
These are her legal heirs are already on record.
already on record. To that effect, order has, my lord, so far as my recollection goes, if my memory is not betraying me, my lord, that has been taken care of by the honorable court.
Apart from 11 respondents, there are no other respondents.
Mr. Bordhon is for, my lord, the appellant. Mr. Orijit Bordhon.
Orijit Bordhon.
But I'll serve him a notice, come back.
The respondents number 1 and 2 are being represented. Where is the learned counsel representing the other respondents? Mr. Banerjee, where is the learned counsel representing the other respondents?
It's not there, my lord. I have given my appearance only.
I'm not asking about that one.
My lord, I'll hunt for him.
Because both in the same boat.
Yes.
To have been
He's one of the
represented.
busiest counsels, my lord, nowadays.
At least somebody should have represented him.
My lord, I'll convey this message, my lord, to Mr.
Respondents number 1 and 2 are being represented. Full stop. Specific thought. The appellants, none is representing the appellants. Full stop. Next. The remaining respondents are also not being represented. Full stop.
Dated LCR.
In their absence, I'm not recording the other submissions.
But I think the LCR.
केवल trial court record.
My lord, this is the matter where my lord was directing the learned judge of the court below to send for the records, and my lord comments were coming that my lord it's not possible.
At last, it has
I
been received.
believe my lord it has arrived. My lord remembers my lord those. But that will suffice.
57 को भी है ना?
Appeal court records have come, my lord, that will suffice.
It was a title appeal টা title suit টা then title appeal টা দিন ঠিক আছে কিরকম ভাবে কি ডিল করেছে এটা টাইটেল সুট এটা টাইটেল appeal এটা টাইটেল সুট ওটা টাইটেল সুট ওটা টাইটেল সুট তলায় যান দেখি টাইটেল সুট আচ্ছা এরকম খুলে রাখলে তো মুশকিল থাক আর documents
My lord, we'll argue from the LCR only.
no are the documents there have you got
My lord,
through
I'll just check. My lord, I'll check.
be kind enough to check
Yes, my lord, I will. My lord, only the deed, that is my lord, the material document. I'm sure my lord, that's there. My lord, I'll just check. I'll check.
একটু দেখিয়ে দেবেন ঠিক আছে ডকুমেন্ট গুলো ঠিকঠাক আছে কিনা
But I'll check. I'll check.
not being represented full stop as the appellant is not being represented the matter could not be taken up for hearing no application pending
To my knowledge, my lord, no application is pending. Kindly do not, my lord, record any submission to.
1 of 2017
No, I'll just. Can 3 was, my lord, for expunging the name of respondent number 6. 1 and 2 possibly may not have been disposed of. Kindly do not record anything, my lord. Today I will just.
but
I'll
is there
ascertain.
any application pending or not
My lord, I'll ascertain. I'll ascertain. My lord need not take the trouble, my lord. I will ascertain.
As the appellant is not being represented so the matter could not be taken up for hearing today
একটা order sheet বানিয়ে নে চেক করে নে can 1 2 3
let the matter appear on 14th of November 2025 full stop the learned counsel representing the respondent number 1 and 2
kindly direct the learned advocate on record, my lord. I will convey.
The learned advocate on record representing the respondents number 1 and 2 is directed to intimate the learned counsel representing the appellant वकालतनामा जान नामे হবে তার সে intimating that the matter will be taken up on 14th of November 2025 full stop
And my lord, in their absence, necessary order would be passed. My lord, if I may intimate that also, that will bring them at least, my lord, to the boat.
then on
Very well. Very well. Great.
Your Lordship,
I am for the respondent.
on behalf of the appellant, Mr. Dutiman Banerjee is appearing. He is on his legs in another court. I am requesting if the matter can be fixed at 2 p.m. I'm requesting Your Lordship if the matter can be.
why not at 12
But that is my instruction because he is in another court, Your Lordship, at this point of time.
take instruction how much time he will take there and when he will be able to appear before this bench
I can just call him up, but I'll ask him just right now if he can appear at 12 o'clock, Your Lordship. Just a pass from Your Lordship.
And intimate this court.
Yes, Your Lordship. I'm just intimating Your Lordship right now. Wait, Your Lordship.
Passed over. Passed over.
Lordship, in
The
this,
appellant.
yes,
number 4.
I'm Lordship led by Mr. Ashish Chandra Bagchi, Lordship. So Lordship,
Learned counsel. We start, whatever remains, that will be,
Lordship, we have to go through the Lordship records also, Lordship. We are not ready. Let a date be fixed, Lordship. On that day, Mr. Bagchi will be also present, Lordship. We will start.
Jasini?
The regular ask.
Any date, my lord, as my lord pleases, may be fixed.
আমি দাদাই ফার্স্ট টাইম আমি অ্যাপিয়ার করছি এখানে।
good for
Good for partition.
partition.
Very long pending matter, madam. Let it be fixed any day, madam.
Any date.
Yes, Chakravarti, the matter can be taken up at. The matter can be taken up at.
Any
No,
date.
no,
No, not
not
today,
on,
Lordship. Not today.
At 2 p.m. করুন।
হ্যাঁ আপনার
আরে আসেনি, আশিসদা তো আসেনি বলছে। আসেনি বলছে।
Oh,
Lordship, I am led by a senior counsel, senior advocate, Lordship. I cannot
he has
start.
not come.
The client has engaged him, Lordship. What can I do?
Let the fixed any day, madam.
Any-
My lord.
Yes, Lordship.
Case
My
will
lord,
be
in
heard.
fact, my lord, Mr. Bagchi will not come all days. My lord, if you lordship fix the date, my lord, he will come.
How can a date be fixed?
Next
Date can be fixed, but
Any Friday, Lordship.
there's no assurance that it will be taken up on that day. If the other matters continue,
My
then
lord, so far my information, my lord, Mr. Bagchi will not come regularly.
Yes.
My lord,
that has been intimated.
that is, my lord, the only fix the date, my lord, he will come. Then the matter can be disposed of.
All the respondents,
My lord, I respond number 1 to 3.
1,
1 to 3.
number 4.
ওর তো সাবস্টিটিউটেড তো হয়েছে নাকি?
না না,
হয়।
ও তো বেঁচে আছে।
of respondent number 1,
A lot of substitution has been done.
Yes, Lordship.
Lot of
1 chaw,
lot of substitution has been.
thereafter
A long pending case, one after one, my lord died, my lord, the
and that
substitution.
the list will increase if days pass by.
My lord, so far my knowledge, my lord, let the fix the matter any day, my lord. I also request Mr. Bagchi to conclude this matter. এই চিত্রটা ছিল তো আগে।
জানি না স্যার, আমি ফার্স্ট টাইম আজকে প্রথম অ্যাপিয়ার করছি।
চিত্তরঞ্জন চক্রবর্তী বলেছিল।
তা জানি না।
Learned counsel,
Lordship.
respondents number 7, 8, 9 and 10,
Lordship.
they have purchased. Respondents number 7, 8, 9 and 10.
Now, purchase না। Substituted.
একটা পেপার বুক যেটাতে সবকিছু পাওয়া যাবে। Lordship, kindly fixes a date. We will come back with all instructions, Lordship.
Yes, all instructions.
Lordship.
Not a single should remain
No.
uninstructed. So all the respondents are being represented.
Hello, hand.
number 4.
4 to all.
4.
No, the appellant respondent হয়ে গেল।
Number disposed of it.
There are 13 respondents. 13, yes, 13 respondents. All are being represented. You are representing whom? Four. Respondent number 4. And in respect of remaining respondents,
remaining respondent কে আছে?
you are representing
1 to 3.
you are
1, 2,
representing
3.
1, 2, 3. They are representing respondent number 4. 1, 2, 3, and 4. The remaining respondents 5 to 13.
Edit respondents.
No, they are substitute, all substitute.
They are not representing.
They have contested before the trial court and the first appellate court. Who is aware of the fact?
No one.
Who is aware of the fact? Are you aware? Are you aware of the fact?
Yes.
The remaining respondents had contested before the trial court and the first appellate court.
No. We also, or
1, 2, 3.
all 4 respondents, we are also not contesting before the title has been.
All along 1, 2, 3 contested in the suit.
1, 2, and 3 contested before the trial court and the first appellate court.
Yes.
And the remaining respondents did not contest. Against them ex parte.
Against them ex parte.
Partition suit.
But Lordship, it's a partition suit.
Partition suit.
আরে করে 1 to 3 contest করেছে all along.
হ্যাঁ আমরাও করি।
When will you be able to
সব নন কনস্ট
clear out the matter?
Lordship, any date after 2 weeks, Lordship, then
2 weeks কেন হবে?
fix করছেন তো।
Yeah, go on next week.
Twenty-one, 21st, Lordship.
21st. Mrs. Chakraborty representing
আরে করেন করেন।
representing the appellant seeks an accommodation
First time in this appeal.
on the ground of
এর আগে ফিজ পায়নি সেজন্য আজকে ফিজ
Learned Senior Counsel Mr. Bakchi. Full stop. In the presence of the learned counsel, paragraph, in the presence of the learned counsels representing the respondents number 1, 2, 3, and 4. The matter is being fixed on 21/11/2025 for hearing. No application is pending.
No, madam.
Mr. Bakchi, request Mr. Bakchi to be present on 21st.
Third time matter fixed.
No, we will do this time. Otherwise, I shall begin.
Yes. Otherwise, Mrs.
No,
Chakraborty.
my lord, before Justice Samanto was fixed.
Oh, not required.
No, before this bench,
Before this
what
bench.
has happened, that will be heard by this bench.
Before this bench today. Much of it.
Item number 13, sir.
Item number 13, yes.
Lordship permits it at 12:30 PM. Would it be possible?
12:30. তাহলে 12:30 হচ্ছে item number 13 টা।
Wait, could you, Lordship?
My lord, I'm led by Mr. Haradan Banerjee. Kindly, I'm praying for the not today, my lord. Lordship, I'm appearing for the respondent number 1, and on the previous questions, One. Yes. Led by my senior, Mr. Masood Karim. Kindly, my petitioner here in appellant. My lord, I have not. No, not my lord.
You are not aware of the
Yes,
fact?
my lord. Kindly fix at 12 p.m. My senior will be here. Today only.
Don't interrupt in between, Learned Counsel. So the other respondents are, you are the landlord. You are representing the landlord.
Lordship.
The other respondents,
They are not appearing.
no. They have appeared.
Not in this court.
You are representing Shomit Samanto.
Lordship.
What is the relation between Shomit Samanto and Deepak Ghosh and Kaushik Ghosh?
Lordship, I am not well aware of the facts. My senior will be on his legs. He is coming at 12 p.m. Kindly fix it.
Learned Counsel, when can you hear out the matter?
My lord.
On which date? Any Friday.
Any Friday means next Friday, 14.
Next Friday.
Yes, ma'am.
The appellant and the respondent number 1 are being represented. Full stop. None is representing the respondents number 2A and 2B. Full stop. ওনার নামটা নিয়ে নেবেন, Mr. Learned Advocate representing the appellant seeks an accommodation for this day on the ground of his senior
Mr. Haradan Banerjee.
Banerjee. Full stop. Paragraph. On consent of both sides, the matter is being fixed on 21st of November 2025 for hearing.
Yes.
On 21st of November 2025. Come prepared.
Great.
Do not seek adjournments.
Great. Lordship.
Will not be granted. Item number 19. Any application pending?
No.
No application pending. Ready for hearing.
Heard by your lordship substantial, it was under the part head.
No, your lordship has said that it will be heard fresh because
ফ্রেশ করবে
ah,
আচ্ছা তাহলে স্যার আপনি শুরু করুন
I have submitted all arguments, my lord, written notes of arguments we have submitted before your lordship, my lord. And your lordship heard this matter several times. Recapitulate.
Not in a prolonged, not extensively or prolonged manner, but
for some material
yes, some
for some material instruction for ours.
No,
no, not for that, but in the
more than
meantime,
1 year back it
in the
was.
meantime, several months have passed by.
Yes.
So once again,
If your lordship,
I'll
before that, your
recapitulate.
lordship kindly look into your lordship's last order dated 22nd May 2025
by way of purchase.
by purchase before the filing of the suit.
He has already been added as a party. Let the appeal be disposed of.
দেখুন তো, written notes of argument you have filed.
Yes.
On behalf of respondents number?
All the respondents.
All the respondents?
Respondents. They are also respondents. My respondents, I mean,
19, 20. I'm for the respondent number 19 and 20.
You are representing respondents number 19 and 20. So, learned counsel, you are representing respondents number? Learned counsels?
Yes, my lord.
আপনি তো অপোজিশন দিয়েছিলেন না আমাকে আপনারা পেয়ে যাবেন
Mrs. Mojumdar has, you have given your written notes of argument?
Yes, I have filed, my lord.
You have filed.
And also I have filed a
Copy served?
Yes.
Huh?
Yes, my lord.
No, no.
I have filed,
I
I have
have-
served copy. Copy of written notes of arguments I have served.
Notes of argument, that is in regard to the second appeal.
Yes, I have
You have filed.
Yes.
দেখুন।
And served, my
নেই। When have you filed?
long back, my lord.
2024.
Yes, ma'am. Long back, when your lordship's heart.
The respondents
Mr.
number 1 and 2.
Yes, Mr. Somo Mujumdar appeared at that time, my lord.
He had appeared in respect of the application seeking addition of party, I think.
No. In the main, when your lordship heard this matter in the paper book at the time of
At the time
hearing.
of argument,
Yes, my lord.
Mr. Mojumdar appeared.
Yes, my lord.
Not
And thereafter, at the
time of
time, at the
hearing the
last moment,
application.
my lord,
I appeared on it.
No,
when
you are
he appeared, my
representing
lord, when your lordship conclude the argument, my lord.
দেখুন তো ভালো করে দেখুন তো থাকা উচিত থাকবে নিশ্চয়ই দেখুন written notes of argument on behalf of the respondent number 1 and 2 নাহলে ওনাকে দিন ফাইলটা দিন ওনাকে ফাইলটা দিন দেখতে দিন এই এনভেলপটাতে এনভেলপের ভেতরে কিছু নেই টুটলো তো ফাইলটা একবার দিন ওনাকে ফাইলটা ওনাকে দেখতে দিন আগে Learned counsel, be kind enough to go through the record whether the written notes of argument is there or not.
I have filed my lord before lordship's matter. Yes, my lord.
So you have a copy of the same.
Yes.
Let a fresh copy be filed. So let us start.
In a file time দেখি
পাবেন না
ও এসিআর সেটা আবার কোথায় চলে গেছে?
একটু এলসিআরটা দেবেন তো উইলটা বের করে দিন উইল এলসিআর ডকুমেন্ট এক্সিবিট গুলো বের করে দিন এলসিআর এ আছে এলসিআরটা দিন না ও তো পার্ট 1 আছে আমাকে দিন বের করে দিতে হবে ওনাকে উইলটা বের ওটা নয় এলসিআর এ আছে ট্রায়াল কোর্টে এক্সিবিট দিন একটু তুলে দিন Your Lordship, this case depends solely on the interpretation of the will. A suit for partition and declaration was filed by the plaintiffs, claiming title
Plaintiffs,
Mr. Mrs.
respondent
Majumdar's plan
respondents number 1 and 2.
Who now you'll page. I'll first place the will and then your lordship I'll make. Inbox আছে নাকি দেখুন তো
স্যার ওই উইলটা মনে হয় খামটার ভেতরে ছিল
দেখি কামটা
খামটা ফাঁকা ওইটা বোধহয় ওখানেই ছিল উইলটা অরিজিনাল উইলটা
কেউ বার করে নিয়ে চলে গেছে
তুমি দেখো না your lordship the will
শুনুন ইনবক্স যদি থাকে তাহলে কি ইনবক্স যদি থাকে ওখানে মানে ট্রায়াল কোর্টে রেকর্ডিং মেনশন করা থাকবে টিন বক্স লেখা আছে কি টিন বক্স আছে তাহলে টিন বক্সটা দিন হ্যাঁ উইথ দ্য কি দিন
ওই তো চাবি আছে খুলুন তো একটু
ওনাদের দিন ওনাদের দিয়ে দিন বক্সটা First of all the documents, all the exhibited documents on behalf of the plaintiff or plaintiffs or on behalf of the respondents, are there inside the tin box?
Yes.
Yes.
It's tagged.
Intact,
Tagged.
tagged together.
Yes.
Exhibit 1, 2.
Exhibit A.
No, exhibit A is for the defendant. Exhibit 1 for the plaintiff. 1, 2. 1 TO 2.
Yes, sir. From the. It is here. That made the wrong.
ধীরে সুস্থ রেকর্ডগুলো ঠিক করে নেবেন, বুঝলেন? ডকুমেন্টস কিন্তু ফাইলটা একটা জিনিস
From the exhibit list, it appears that exhibit list of the defendant is given. List I will আছে দেখতে পাচ্ছ না। Plaintiff's exhibit list is not here.
documents are here.
Yes, I think so.
I think so.
It is there. The documents are tagged.
But the list is not there.
No.
Huh?
Because in this it is said exhibit A to J.
That is for the defendants.
Defendant.
And exhibit for the plaintiff or plaintiffs.
Its list is not here.
No, as regards to the documents.
I do not know if
Mrs. Mojumdar, you had represented the plaintiff or the plaintiffs. How many documents did you exhibit?
Your Lordship will take.
Oh, okay. She can only say that whether the plaintiffs or plaintiff.
প্রথম প্যারাগ্রাফে
Series of Potcha. Exhibit exhibit A series, B series, C series, D, E, F, G, H, I, and J.
এরপরে থাকবে ইস্যু পাঁচটা পাতা বেরিয়ে গেল
পেপার বুকটা দিন, পেপার বুকটা দিন, পেপার বুক।
Correct. paper book evidence पावे की second give evidence of
ট্রায়াল কোর্ট রেকর্ডটা একবার দিই, ট্রায়াল কোর্ট রেকর্ডটা দেখছেন? How many witnesses adduced evidence on behalf of the plaintiff or plaintiffs?
plaintiff I think
From their evidence,
15 evidence.
it can be gathered whether they had proved any document or not.
16.
ট্রায়াল কোর্টে ট্রায়াল কোর্টের রেকর্ডটা আমাকে দিন, বুঝছেন? ঠিক আছে, ঠিক আছে। একটু পজ করতে হলো, লাইভ স্ট্রিমিংটা পজ করতে হলো।
document was exhibited, that was the will, probate by the executive. Only one that is there. Yes.
Yes.
Will is there. I have marked it. It is there. Upota din.
Side
Side
tag.
Side
tag.
sticker. Side sticker. That is the probated will.
The will data, yes.
Now, your lordship will kindly go.
Yes.
Kindly go through the will, then I'll make.
Acha.
তুমি না করতে পারলে
What I am reading.
হ্যাঁ পড়ো পড়ো
No, need not be. Let me go through. Let me go through.
না না ওই যে ওর মুখটা নোংরা এটা সাদা কাগজ তুমি একটা দিয়ে লেখা হবে না জাস্ট একটা কাগজ এইটাই হ্যাঁ এইটাই খুব আগের হচ্ছে কপি আমাকে দিলে আমি বলবো তোরটা ওখানে আছে একটা যদি যে ফাইলটা জজের যে জজ সাহেবের যে ফাইলটা আছে না, জজ সাহেবের যে ফাইলটা, মানে আমাদের হাইকোর্টের যে ফাইলটা, তার ভিতরে দেখুন এরকম একটা বাংলায় টাইপ করা একটা পেপার, এটা উপরেরটা না, নিচের, ওর নিচে তুলুন তুলুন পুরোটা, ওই বান্ডিলটা নিচে, ওই বান্ডিলটা, ওই বান্ডিলটা আমার এই মামলারই তো, এই মামলা নয়। না না, হাইকোর্টের যে ফাইলটা, হাইকোর্টের ফাইল উপরে আছে, উপরে আছে, ওটাতে এরকম একটা বাংলার কপি আছে, দেখে ওটা জজ সাহেব, নাহলে দিন আমাকে বের করে দিচ্ছি। ওই তো ওখানে আছে বাংলাটা, নোটা 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 এইভাবে
Your Lordship has seen. Kindly take for once again paragraph clause 1. That is the main interface. I'll place that. না আমার যে সকল স্থাবর সম্পত্তি আছে তা আমার কন্যাগণ যথাক্রমে শ্রীমতী সরোজ বাসনী দাসী, শ্রীমতী দাসী, শ্রীমতী আশালতা দাসী, এই 3 কন্যা সৌম্য অংশ প্রাপ্ত হইবে এবং তাহার আজীবনকালে পর্যন্ত দখল করিবে। Means they will life interest for the 3 daughters after the death. Then তাহাদের আজীবন ভোগ দখল করার পর তাহাদের গর্ভজাত পুত্রগণ। Your Lordship, I am laying stress on গর্ভজাত, that is uterine son. তাহাদের নিজ নিজ মাতার সম্পত্তিতে পূর্ণ সত্ত্বের মালিক হইয়া ভোগ দখল করবে। ঈশ্বর না করুন যদি কোন কন্যার সন্তান না জন্মায়, তার কন্যা থাকিলে সেই মালিক হবে। If there is no uterine son, then the daughters will get it.
যদি কন্যা না থাকে,
যদি কন্যা না থাকে অর্থাৎ সে সন্তান
সন্ততিবিহীন হয়,
তাহলে
অপর কন্যাদের
পুত্রগণ
সমঅংশ তাহার সম্পত্তিতে,
পুত্রকন্যাগণ সম অংশে তাহার সম্পত্তি পাইবে। Means if any of the daughters die issueless, her property will go back to the surviving sons and daughters of the other sisters. Now the next is clause 3. Next page, Your Lordship. ঈশ্বর না করুন আমার বর্তমানে কোন কন্যা মৃত্যু হইলে তাহার গর্ভজাত শিশু কন্যা, kindly see, she is laying the testator,
না গর্ভজাত
শিশু কন্যা দেখো তো এখানে কি 3, yes, হ্যাঁ তারাই জীবিত থাকলে, Your Lordship will kindly consider, reconcile this. Who are surviving the uterine daughters and sons? That is the will. It's very clear. Your Lordship, this will, there is no ambiguity what the testator wanted. Now Your Lordship will come to the case. Facts of the case. Your Lordship, I have given a genealogical table. You must, Your Lordship must be having. কোনটা? না ঠিক আছে। Your Lordship, Siddheshwar Ghosh was the testator. He had 3 daughters. No, 3 daughters are Charubala Dasi, Hemburun Dasi.
He had
Two wives
and 3 daughters.
3 daughters. Now, Your Lordship, there is no dispute with regard to the mother and wife because they have expired. Now, the 3 daughters, Your Lordship will kindly see. Your Lordship will take Saroj Pasini Ghosh. She died on 25/7/1992. Your Lordship will kindly mark this one. The date. He had 1 daughter and 2 sons. Rajnandini is the daughter, Prafullo Kumar Ghosh is the son, and Santosh Kumar Ghosh. Santosh Kumar died in 1991. So he is the predeceased son of Saroj Basni. On the date of death of Saroj Basni, his only uterine son surviving is Prafullo. So our case is that Prafullo inherited as per the will. Because Your Lordship will know that when the devolution opens, it opens on the death of the person. It's not before that. The day Saroj Basni Ghosh died, on that day the devolution opened up. And the heirs as per the will, who was surviving, they will inherit. Not the predeceased, because Your Lordship, there is no mention that sons and daughters, specific uterine son. And the plaintiffs who are the daughter of predeceased son, they are not entitled to. On the date the devolution of state of Saroj Basni took place. Now, with regard to Asalota, the other daughter, then it will go to the daughter, uterine daughter. But on the date when Saroj Basni died, a son was surviving.
Only one.
Ghosh.
Only.
So the entire state of 1/3 share of Saroj Basni devolved on Prafullo. Because she is a daughter. If there is a son, it will go to the son. Only in the absence of son, it will go to. Now, with regard to Asalota Ghosh, this second daughter of the, there is no dispute. Sons and daughters are there. Now, with regard to Snelota Ghosh, they are the sons and daughters of Asalota.
And
Yes.
they will inherit the property.
1/3 property of
Asalota.
Asalota. There is no dispute with it.
But not Sunda. But not Sunda.
From the daughter.
No, the sons will get.
Only sons.
Not the daughter, because the sons are surviving. Now, Snelota Ghosh died issueless. Now, as per the will, Your Lordship, if she died issueless, Your Lordship, clause 1, the second half of that, it will devolve on the surviving sons and daughters of the other sisters. Your Lordship has got that. That will, last portion of.
বিহীন হয়
equal share Now, your lordship will see it is stated that the sons and daughters surviving, not the grandsons or this. Putro Kornagon, your lordship will kindly see. So, your lordship, when Snelata died, 1996. At that time, the plaintiff, that is the daughters of Santosh Ghosh, they were not the sons and daughters of other sisters. They were the grandchildren of Saroj Basu. So it will go to Rajnandini, Profullo, and sons and daughters of Asalota. The plaintiffs do not inherit anything from Snelota because they are the grandchildren. So the plaintiff claim partition as heirs of Santosh predecessor. The date of death is relevant, very much relevant. The plaintiff's case yes, 1/3 chair. Rajnandini and Rajnandini, daughter of Saroj Basini, Profullo Ghosh, of Saroj Basini, and Sunil Ghosh, Sunil Ghosh, Anjan Ghosh, Sosti Ghosh, Rabindranath Ghosh, Sandhya Ghosh, and Sridhar Ghosh.
1/3 to be default.
One-eighth of 1/3, that is 124.
3, 4, 5, 6, 7, 8, 1/8. To 1/3.
Not the grandson or the granddaughter? No, as per the interpretation of the will. Direction under the will, it will go to the sons and daughters.
Intention of the testator, according to you, the intention of the testator.
Because the devolution opens on the death.
Yes.
The plaintiff claimed their share to Santosh Ghosh, being the predeceased son of Saroj Basu. Their case is that, and they are entitled to it. That is. Not a normal inheritance.
Yes. Yes, Learned Counsel. Next point.
So, Lordship has seen that Saroj Basni died on 25/7/1992, leaving surviving Profullo Ghosh, uterine son, Rajnandini, daughter, Susti Mondal, the plaintiff, and Osima Kaviraj, the plaintiff. Grandson, her granddaughters, being the sons of Santosh Ghosh, daughters of Santosh Ghosh, who died in 1991.
Yes. Next point.
Your Lordship, my submissions are in this appeal that the suit for partition is not maintainable at all at the instance of the plaintiffs, as they do not have any right, title, and interest in the property, and they have not inherited anything under the will. From the plain reading of the will, Your Lordship, it was the intention of the testator that after her daughter's death, their share, respective share will devolve on the first on the uterine son, then on the daughter, thereafter other heirs. No, then if there is no sons and daughter, it will go back to the other surviving
Sons
sisters,
and daughters of the sister.
or not to the grandsons or grandchildren. Your Lordship, this is very clear. Now, both the courts below did not consider this aspect of the case and the will, terms of which was very clear. They interpreted that Santosh Ghosh is the predecessor son of Saroj Vasani, and the plaintiffs are daughters of Santosh Ghosh, class 1 heirs under the Hindu Succession Act, so they will be entitled to this share. But here, Your Lordship, under the will, the Hindu succession has been given a go by. The inheritance has been altered.
That's why a will is made.
Yes, it has been altered. The court did not consider that aspect at all.
Court took into consideration the general perspective.
Class 1 heirs under the Hindu Succession Act, granddaughters, and they will inherit.
Anything more?
Your Lordship, in this, I'll cite some of the judgments. Your Lordship will kindly note that.
Already cited?
I'll cite it. Your Lordship.
Learned counsels, have you received the genealogy?
Yes, last date I have given.
আমি 19-20
ও আচ্ছা
আমাকে একটা দিন রাখছে তাহলে ছবি তুলে নিচ্ছি
না না দিয়ে দিচ্ছি
ওই দিয়ে দিবি রাতে ছবি দিচ্ছি থ্যাংক ইউ
As regards to genealogy, do you controvert anything?
My lord, Your Lordship kindly hear this matter next Friday. I will answer this point.
না 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 উনি বলছে আমি যে লিস্ট দিয়েছি জেনেalogical টেবিল সেটা কি ডিসপিউটেড?
No,
there is no dispute.
দাও আমাকে দাও এক একটা বলছি।
So next we will argue.
No,
I'll just
Thereafter,
regarding my ownership, there is no dispute.
Thereafter, on the next day, an opportunity.
I'll just hand over the judgment to Your Lordship, and then Your Lordship. Your Lordship, kindly I'm citing orders how the will is to be interpreted. Judgment, Your Lordship will kindly take it. Orders construction of deeds and statutes.
This is here. It has already been submitted
Yes.
on an earlier occasion.
Kindly take rule 2 of interpretation. Originally, parties use apt words to express their intention, but often they do not. The cardinal rule again is the clear and unambiguous words prevail over any intention. But if the words used are not clear and unambiguous, the intention will prevail. Your Lordship, what I am submitting, Your Lordship has seen the will. It's a very short will. It is clear, there is no ambiguity as to who will get the property, how it will develop. So there cannot be any further interpretation or something in the will. Clear intention is to be given. Then Your Lordship will kindly take down.
Has a copy been provided? Copy been provided of this one?
No, it's a book, Your Lordship. I'll give it.
Your Lordship has handed over to your Lordship, sir. I have taken.
That was to be handed over to the learned senior counsel.
I have taken one.
I'll give it.
Because he has a copy, then I.
Last date, Your Lordship, then I'm citing Your Lordship 90 AIR 1920 Privy Council. Page 103. It's not there. I think.
It is not here.
I'll
10.
103. Page 36, Your Lordship will of that judgment.
Page
36 of that judgment.
No, you are referring to.
No. Your Lordship, I'll give. At page 106.
106.
Your Lordship has got that?
এটা তোমার আমারটা কোথায়? এটি তো না, এটা সব পেজ নিয়ে করে আছে।
এটা আমার নয়। Your Lordship will come to page 106, right hand column. The last sentence is about 3-4 lines from the bottom. In these circumstances, Your Lordship has got that?
These circumstances surrounding the making of a deed.
Making of a will.
Making of a deed.
Making of a deed may, if it be ambiguous, give to the words a special meaning. But if the meaning of the deed, reading its word in the ordinary sense, be plain and unambiguous, it is not permissible for the parties to it.
Last page.
Last page? Huh? একটা পেজ মিসিং করে দিও বাহ
দিয়ে দিন এটা
কোটা
এইটা 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 এই পেজটা ঢোকানো হয়নি something else is written there contrary,
he has not stapled.
Contrary to your submission.
No, he has not stapled that page. একটু পেজ একটা
এই যে আমার কাছে আছে আমার কাছে আছে আপনাদেরটাই নেই আপনার এটা না ইয়েস আপনাদের এটা The circumstances surrounding the making of a deed may, if it be ambiguous, give to its words a special meaning.
But if the meaning of the deed, reading its words in their ordinary sense, be plain and unambiguous, it is not permissible for the parties to come to the court of justice while it stands unreformed and say our intention was wholly different from the language and deed expression. Next page, Your Object.
It is not permissible for the parties to it while it stands unreformed to come into a court of justice and say our intention was wholly different from that which the language of our deed expresses.
Yes. This one give a different interpretation.
Yes.
তারপরে তো
According to you, what is mentioned in the deed, it is unambiguous.
It is to be meant as it is, the words are there. Because those words used are not sons. He could have said sons and daughters. Why, Garbhojat? Because only the uterine sons will inherit. That meaning has to be given to all the words. Then, Your Lordship, I am citing 1963, the Supreme Court.
This one was the first citation. AIR 1920 Privy Council.
Yes. Your Lordship will take paragraph AIR 1963 Supreme Court 1703. Paragraph 5 at page 1705.
Yes. Yes.
Your Lordship has seen paragraph 5.
Yes.
Kindly come to the last portion. The words occurring more than once in a will
Same meaning.
shall be presumed to be used always in the same sense. Uterine son cannot be interpreted as grandsons or grandchildren. And paragraph 7, Your Lordship. If the Your Lordship has got that? If the arguments of the learned counsel for the appellate be accepted, this court would be rewriting the will for the testator.
Learned counsel, which portion you are placing?
Paragraph 7.
Paragraph 7 in page 1705.
Just it. 06.
1706. Which portion? Yes, learned counsel.
In the argument of law. Conclusion.
05. Your Lordship has got 1706.
Yes, 1706.
At the bottom, Your Lordship. About 7-8 lines from the bottom.
Yes.
If the argument of the learned advocate, Your Lordship, kindly mark that.
Learned counsel for the appellant be accepted.
Accepted.
If the argument of learned.
This court would be rewriting the will for the testator. It would be cutting down the meaning of the words which the testator designedly used to convey a larger interest to his wife. Further, where one of the two reasonable constructions which lead to intestacy, that would be discarded in favor of construction which does not create such a right. Means, Your Lordship, if different meaning is given to the will, then Your Lordship, the purpose of will is defeated. It was testacy inheritance under the will, not intestate, without a will. But the trial, both the courts below gave an interpretation to the will, declaring that the daughters of predeceased son was entitled to it. It opens a general inheritance without there being a will.
So according to you, either the court, both the trial court and the first appellate court has overlooked that one or misinterpreted it?
Yes. Because, Your Lordship, if the interpretation which both the courts gave and declared the right title interest of the two grandchildren, then the very purpose of the will is being defeated. That court cannot do.
The intention of the testator was to give to the sons and daughters.
Surviving uterine son.
Sons and daughters of the other sisters.
Yes.
Not to the grandsons.
Not grandson. And also, in case of inheritance from the mother, it will go first to the uterine son, surviving, then to the daughter, not to grandchildren. But what the court has done here, court has given a go-by to the will, general interpretation under the Hindu Succession Act that he has applied. Both the courts. That the court cannot do. He cannot rewrite a will for the testator.
When the probate was obtained on 12/3/1951.
Yes. Now, the next judgment I'm citing is 2009, Volume 3, SCC 287. দাও আমাকে দাও তোর সাহেবকে দাও
SCC 287.
হ্যাঁ 287. Kindly take paragraph 3. No. Your Lordship will give me. Your Lordship, it will be paragraph 30, not 3.
30.
The will is required to be construed on the basis of the terms used therein and not otherwise.
Para 30, 33, 33.
Your Lordship.
Yes, paragraph 33. Which is referred to
3 and 4, Your Lordship, of paragraph, subparagraph 3 and 4 of paragraph 33.
which are extracts from 1976 1
Yes.
SCC 630.
Yes. Your Lordship has got that?
Yes.
Stop. 2006, 13 HCC.
737. Right. Dada.
The next judgment I am citing, Your Lordship, is 2006, 13 HCC 737. Paragraph 34. Your Lordship has got that, paragraph 34. When a document is not uncertain or does not contain any ambiguous expression, it should be given its literal meaning. Only when the contents are not clear, the application of principle of construction of a document have to be applied. It is not a case where there exists any inconsistency between an earlier and later part of the document. Your Lordship, this is the law of interpretation of documents and will. The will, Your Lordship, my submissions are the will has to be read as a whole, with all its provisions, ignoring none as redundant.
And should be given literal meaning.
Literal meaning. When it is not unambiguous, it's clear. And Your Lordship, the other submission is that while interpreting a document, first grammatical and literal meaning is to be given. Or they used in ordinary sense. Your Lordship, the person who has done this, executed this will, he was a villager. What he meant by Gorbojat son, everyone knows. It cannot be interpreted to mean grandchildren and sons and daughters of predecessors. Then, Your Lordship, I have already submitted, if the word is appearing a number of times, it has to give it same meaning. And Your Lordship, the will is not to be interpreted in a manner which makes the inheritance intestate. Because the will is for ignoring the intestate inheritance, altering the line of inheritance,
breaking the general
general law.
trend.
It cannot be interpreted so that the will is a nullity and the general law prevails. This cannot be done at all. If the court does that, the court will be writing a will, rewriting it. Then, Your Lordship, the next judgment which I am
more judgments.
Oh yes, one more judgment. No, 17. No. Okay. B SCC 273 DH in
2006.
79. Your Lordship, the next judgment which I am citing is 1979 3ACC 273. Huh?
1979 3 so to ACC
Yes,
273.
down again. Your Lordship, paragraph 19. Your Lordship, I'm citing this because, Your Lordship, what is the date of devolution? Paragraph 19, Your Lordship will find such ascertainment of heirs of testator. Paragraph 19.
Yes.
Your Lordship has got that? Such ascertainment of heirs of the testator is to be done on the date of Datara's death without mail issue, when succession opens out in favor of those heirs and not with reference to the date of death of the testator. Your Lordship, here the testator died long back. But when Saroj Vasni died, who are the heirs under the will is to be considered. Not when the testator died. That is the interpretation. So we cannot claim the granddaughters of Saroj Vasni cannot claim that on the date when the great grandfather died, my father was alive. Because devolution opened on the death of that person, Saroj Vasni. And Your Lordship, I don't have to say what is the meaning in Bengali of Garbhajat Putro. And the last judgment which I am citing, Your Lordship, is...
Honest Counsel, you have already cited 5.
No, and the last judgment which I am citing is 1994 SC AIR 1202. That was cited by my learned friend, Ms. Majumdar. Your Lordship, that judgment was cited. Your Lordship, with regard to that judgment,
AIR 1994.
4 SC 1202. No. Your Lordship, in this case,
Bhura versus Kashiram.
Yes, this does not apply at all, Your Lordship, because it was with regard to what is the scope of limited state. Paragraph 2, Your Lordship will kindly consider of that judgment.
She has referred to paragraph 3.
Yes, but 2, before that, kindly refer to paragraph 2. What is the dispute? What was there? The only controversy between the parties which was contested both before the trial court and the high court was whether the will, exhibit 4, conferred only a remitted state or an absolute state on Sarjabai insofar as a suit property is concerned. The learned district judge held that the state which was bequeathed by Pancham to defendant number 1, Sarjabai, gave her an absolute right thereto, and consequently, except on the question of adoption, the suit filed by the plaintiff respondent was dismissed with cause. This was whether it was a limited state under the will or it was an absolute. So, Your Lordship, but here it is not the case. In our case, it is different. In our case, the plaintiffs have not claimed limited state of the 3 daughters of Saroj Basni, grandmother, under the will. Under the will, she is not claiming. She is claiming inheritance of her grandmother's property under the general law. And Your Lordship, this was a limited state of the grandmother. So there cannot be a general law of interpretation of inheritance. And Your Lordship, the other aspect I am submitting is that the shares which the court calculated only for the plaintiff. In partition suit, all the shareholders' share is to be declared. Nothing of that sort was done by both the courts. And also, a share which was declared for the plaintiff, that is 2 granddaughters, was more than what they get it from the normal interpretation. Whatever they have said, they are entitled to the share of their father.
If they are at all entitled.
Entitled to. Then, Your Lordship, their father only inherited 1/6. 1/3 is Saroj Basni. 2 sons were there. So she will be inheriting 1/6 and 1/8 of the Asalota. Snailota. 1/8 of Snailota. And 1/6 of Saroj Basni. That doesn't come to the shares they have claimed. And the court just passed a degree on the basis of prayer in the plate. Without that, there was no application of mind in the case. Leave aside anything else. And the court was completely oblivious of the fact of the case. According to, even if it's take it, Koto? She will be, even Your Lordship, if I, as it has been submitted, calculation done on the basis if Santosh, her father, their father was alive, then only they will get 5/18, not 5/8. And the court, without nothing has been done in this case at all. Your Lordship will go through the judgment, Your Lordship will know. The plaintiff do not have any right in the suit property at all under the will.
You have concluded?
Yes. I'll hand over the written argument to Your Lordship.
Written notes of argument coming week on Friday. Lord Counsel, after recess?
Yes, I will take coming 15.
After recess.
After recess, sir.
Recess. Oh.
সবই আছে এখানে সেকেন্ড ছেড়ে দিন
No, last minute.
You can start.
Yes.
Now for the respondent number 19 and 20. We have been added as a party in the present appeal by an order dated 8 May 2025. Kindly see your lordship's order.
May 2025.
Yes, my lord. Not kindly also look into Can 4 of 2020, my application for addition of parties.
Whether department has incorporated the name of the.
Yes, it's already incorporated in the paper. Last question also I have checked up.
Chief Shankar Kejriwal and Reshmi Kejriwal,
Yes, ma'am.
19 and 20.
I disposed of it. But kindly take up Can 4. It is
Can
already on
4.
record. Yes. It's a disposed of, but it is in your lordship's record. Can 4 and the supplementary affidavit to the Can 4.
কি বলি ওটা ওটা আপনাদের ওটা ওটা এটা আপনাদের কাছে এটা একটু আসতে গেছে চলবে গরম লাগছে ঘাম হচ্ছে যাবে Can 4.
But old number was 1827 of 2020. 1827 of 2020.
1827
of 2020.
2020.
Yes, right. And one of the supplementary affidavit affirmed that with the said application.
Supplementary affidavit is also required.
Yes, madam, because certain deeds has been disclosed by one supplementary affidavit. But supplementary affidavit should be in bond paper, in white paper, because it was affirmed in 2025. Second appeal. Second appeal.
Supplementary affidavit.
Yes, my lord, on 3rd March 2025. Affirmed on 3rd March 2020. Got it. Number, may I?
Third
3rd March 2020. But kindly take these two and the geological table submitted with your lordship by Mr. Srivastava, my landed senior friend. Number my landed senior friend, taking clue of the submission of my landed senior friend, I'm submitting that Siddheshwar Ghosh died leaving behind 3 daughters, 2 wife, and lordship 1 mother. The 3 daughters are lordship Sarojbasini Ghosh, Ashalata Ghosh, and Sneholata Ghosh. Now, your lordship, my landed senior friend shows your lordship demos. So, kindly see, the first is the wife, Charubala Dasi.
Charubala Dasi. First
Then,
wife.
yes, first wife. Second wife, Himrani Dasi. Himborani, I'm sorry, Himborani Dasi. The daughters are Sarojbasini Ghosh.
No, another name has been mentioned here. Puritosh.
Himrani Dasi was her mother.
Himborani Dasi was the mother.
Mother. 2 wives were Charulata and Puritosh.
Charubala and Puritosh.
2 wives.
2 wives.
Himrani was the mother. And 3 daughters. Sarojbasini Ghosh, Ashalata Ghosh, and Sneholata. My landed senior friend has categorically submitted and demonstrated before your lordship clause 1 and clause 2 of the will, by which the 3 daughters, we can there Sarojbasini, Ashalata, and Sneholata. Again, Sneholata, she has died without any issue. So her case may be taken rest at the present moment. But I am claiming share from Ashalata Ghosh. The plaintiffs are the heirs of Sarojbasini Ghosh. The plaintiffs and the defendants 1 and 2. We are claiming share from Ashalata Ghosh. The Ashalata Ghosh died leaving behind 4 sons. Sunil Ghosh, the daughter is Anjali Ghosh, Sati Ghosh, Shoshti Ghosh, Rabindranath Ghosh, Sondha Ghosh, and Sridhar Ghosh. Let's kindly see the Ashalata Ghosh died in 1992 and Sridhar Ghosh is died in 1999. But after
You have purchased from
Sunil,
Shoshti
T.
Kumar.
Rabindranath, Dulali, Sugoto, and Ashish.
1 minute. You have purchased from Sunil. Where is the name of Sunil?
Sunil is the first person, Sunil Ghosh, in the geological table.
No.
In the Dolil, in the deed.
In the deed.
Yes, my lord. The Dolil Data, Shoshti Kumar, Sunil is the third.
Three. Sunil Kumar Ghosh.
Then my lord, Shoshti Ghosh, Shoshti Kumar Ghosh.
Anjali.
Anjali is the daughter. Anjali, she will not be, as per the will, she is not entitled for the property.
She did not obtain any share.
She did not obtain any share.
Achha. Shoshti Ghosh, vendor number 1.
Yes.
Rabindranath Ghosh, vendor number 2.
Then my lord, comes Srimati Dulali Ghosh. Dulali Ghosh is the son of a deceased son, the wife of a deceased son. The son died after the death of Ashalata, after reopening of the inheritance. So, the Dulali, Sugoto, and Ashish, the wife and 2 sons.
Dulali Ghosh, wife of Sridhar Ghosh.
Who died in 1999. Dulali, so they have the shares in the property. I purchased from this side. There is no dispute, there is no claim either in the suit for partition that against us. But we are not made a party.
You were not made a party.
We are not made a party. If the plaintiff got any share from the suit property,
you have purchased the property on?
We purchased the property on, I'm giving the date, exact date, in 2002, 28 June 2002, before institution of the suit.
28 June 2002, prior to the institution of the suit.
Yes.
So, learned counsels, as regards to their share, obtaining their share from the vendors, there is no question?
Yes.
There's no question as regards to
when the application was made by him for addition of party, I did not object.
You did not object. That is
because either of the case, the plaintiff or the defendant will not get any.
I did not make any
it was hardly contested by.
But unlimited property
I
unlimited.
did not make any
But unlimited property claim, my lord. This is partition should, man.
No.
So either of the case, the plaintiff who is the respondent 1 and 2 before your lordship, they will not get any share from the Ashalata. They will not have any claim from the share of the Ashalata. I purchased the property from the heirs of the Ashalata after the death of the Ashalata, after the reopening of the lordship, the inheritance. Firstly, secondly, lordship, I'm very much lordship adopting the my senior friend regarding the maintainability of the suit, because a party who is not a shareholder or not a co-sharer of a particular plot of land or particular estate of a deceased, she is not entitled to lordship prefer any partition suit. This is not a clear, simple case of declaration that whether she is declared to be an heir or she is entitled to be an. This is a partition suit, and not being a owner of a particular property, she cannot be claimed any share in the property. So
you are at one with Mr. Srivastava.
Yes. Very much adopting the submission of my senior friend.
No, his right is also being affected to some extent.
Because
Snehalata's share, they have claimed.
Snehalata's share will be.
What Snehalata's share also? His vendor.
My vendor.
his vendor got share in Snehlota's 1/3. Because she died issueless.
Yes.
Another half.
Sons and daughters.
Half of Sneholata.
Half of
Not half. There are number eight years, eight such.
No.
No,
After
I'm not
that-
going into that one. On the death of Sneholata, half.
Not half. Not half. All the sons and daughters in equal share. That is the will.
All the sons. He had all the sons.
The sons and daughters.
Yes. My lad is absolutely right. Absolutely right. I'm wrong.
It's not that the two
Yes.
sisters will get half.
Because all the sons, the grandsons of Siddheswar will get.
Will. First paragraph, last portion.
অপর কন্যাদের পুত্র কন্যাগণ সম অংশ
ইকুয়াল শেয়ার
সম্পত্তির পূর্ণ সত্ত্বে মালিক হইবে।
So
eight is 1/3,
either of
1/24 he is having, and they have claimed that portion, his portion also.
either of the way, my right will be infringed. My share will be infringed by the order infringed, which was subsequently affirmed by the lower appellate court. And regarding my ownership, but I purchased, I showed to your lordship 2002 deed, by which, if you also kindly see the deed once, page 19 of my application, 2 persons purchased the property, one Gopal Kejriwal and one Shiv Shankar Kejriwal. Now, thereafter, by way of an deed of exchange, which is annexed in my supplementary affidavit, this property, which is the part of the instant suit,
I think amicable partition.
Exchange.
বন্টন নামা।
Rather, it should be described as deed of exchange, because the citation and the body of the deed says it's an exchange.
Something else.
It is exchange. If you also kindly see the toposil, the schedule, there were two property and one property obtained by the respondent number 19 and 20, that is Shiv Shankar Kejriwal and Reshmi Kejriwal, and another property was given to Gopal Kejriwal and Suman Kejriwal.
Shiv Shankar Kejriwal and Reshmi Kejriwal.
The husband and wife, both are husband and wife. And the second one is Gopal Kejriwal and Suman Kejriwal. Two brothers purchased the property. Thereafter, they amicably settled between them. So, either of the case, regarding my entitlement, regarding share of Ashalata, there is no such dispute. Firstly,
you have right title and
interest over the suit.
But to what extent?
To what extent?
That is the question.
That is the question. That is required to be determined by the trial court after giving me a proper opportunity of hearing. In that score, if you also ultimately hold the suit is maintainable, because in my respectful submission as on today is that suit is not maintainable because of the clause 1 and clause 3 of the will, which my landed senior friend shows to your lordship. In either of the case, if your lordship holds that the suit is maintainable and your lordship ultimately decided to remand the matter for fresh trial, then I should be heard at the time of fresh trial. But as on today, as my learned senior friend has correctly pointed out before lordship and correctly submitted, as per clause 1, when there is a specific intention, specific will of the testator regarding the development of the property, that should be given precedent over the general law of succession. If that be so, that the plaintiffs who claiming the share of the property from his predecessors who died, who predeceased his mother, because the inheritance open only after the death of the mother, as per the will. So a predeceased son, the daughter and sons and the heirs of the predeceased son cannot claim inheritance by way of inheritance from her predecessor, but in terms of the clause 1 and clause 3 of the. In my respectful submission, the suit itself is not maintainable and required to be dismissed in the first instance. In either of the case, if your lordship holds that the matter should be heard afresh, then we should be added in the suit itself, and we should be given opportunity to be heard, and the lordship after framing of the issue, and lordship after giving a fresh trial. Now that is my case. আর তো কিছু নেই আমার বলার। That is my case. There's nothing more I have to cover. If you also so desire, I can file an active notes.
You can. But on
Then my next Friday I will submit
on
before
14th,
all the points.
positively.
Give precedence to partner the top.
At the top part.
Kindly, so that it is completed.
It will be item as item number 4, because 3 matters have been earlier fixed on 14th. As per the
Little bit.
fourth item number 4 will be this one.
Next Friday.
Next Friday. The learned counsel representing the appellants have completed his submission. Full stop. Next line. The learned counsel representing the respondents number 19 and 20 has also concluded his submission. Full stop. Counsel representing the remaining respondents remaining respondents you are representing all the other respondents.
1 and 2.
Only 1 and 2.
Because other respondents are expert before the learned trial court. They are the plaintiff.
Last sentence of hearing. Submission. The learned counsel representing the respondents number 1 and 2 public plaintiffs seeks an accommodation for this day and submits that on the next date, that is on 14th of November, we will place our argument. As per the submission of learned counsel, let the matter be fixed on 14th of November 2025. Eta item number 4 হবে, ঠিক আছে?
But kindly pass only one word. If you also kindly see order dated 22nd May once. There is a typographical error. That's
22nd May.
Seventh line from the top. First paragraph, 7th line.
First paragraph,
Wait a
seventh
minute.
line from the top.
My lord, the deed of exchange dated 6th October 2025. It should be 6th October 2005.
Oh, a deed of exchange.
Yes, yes. That is in the supplementary affidavit. 6th October 2005. Wrongly. I can type of that. It is on down as 6th October 2005.
This is the supplementary.
Yes, yes. না না এটা তো এই ডেটটা 2005 হবে 2025 হয়ে গেছে ওটা কালেকশন জন্য বলে দিতে মে আই হ্যান্ডস আপ মাই কপি
No, no, no. It is here. Just now it was here.
even A4 bond paper ও হ্যাঁ বোঝা যায় না
In opposition, can for a supplementary. Supplementary.
certified copy
Hmm. 6th of October 2005.
2005 it was written 6th of October 2020
Oh, acha, acha. And next paragraph. In the order, in the eighth line of the order dated 22nd May 2025, as regards to the deed of exchange, as regards to the date of deed of exchange, it has been typed as 10th October 2025.
6th October
Sorry, 6th October 2025 instead of 6th October, 6/10/2005. 2005. The said order dated 22nd May 2025. In the said order dated 22nd May 2025, the date of deed of exchange be read as 06.10.2005.
much of that yes
The will go in the tin box.
Yes, the entire
Yes,
entire document. And to the court, this genealogy is also a vital document.
Yes. No, not only the table, but the date of death is also, that is important. who died when,
Yes.
because everything depends on that.
স্কুলে নিয়ে যেত
যেগুলো ফিক্সড হয়েছিল না টাইম 12 PM 12 noon 12:30 PM যেগুলো ফিক্সড হয়েছিল টাইম দিয়ে সেগুলো আগে আছে তো?
My lord, I'm for the respondent. No. Mr. Banerjee, yes, he was there, but now he is not there.
Then what can be done? It is
Then lordship next week.
next week. Otherwise, there is no other alternative.
Yes, lordship. Kindly adjourn it for the day.
No, the respondent was being, sorry, appellant. The appellant was being represented.
Yes, he was just now there, lordship.
Just now he was there. So
Before the break, he was there, not in this half.
So no order is being passed. Otherwise, it has to be stated that none is representing.
Lordship. We shall inform him. Okay, just phone call.
আর কোনো নেই তো? হ্যাঁ, ডাকুন।
Item number 21, password.
My lord, I appear to be petition this matter. My lord will recall there are 5 applications pending for your lordship. The Can 1 application is regarding my lord my section 5 application arising out of this appeal. Can 2 your lordship is the stay application of the impugn judgment matter.
It has not yet been admitted.
No, not yet be done.
So
Can 3 my lord is
so
the
the
substitution
the question of stay does not arise at this juncture.
The substitution, my lord, I have also taken out an application, my lord. Can 3 is the substitution application?
Can 1 is also a substitution application.
Can 1 is my lord section 5.
It was filed long before.
43
At the time of
yes.
At the time of filing.
Yes.
Can 3 is a substitution application. Can 5?
Can 4 is your lordship. The Can 5 is the setting aside of abatement.
There's no Can 4.
No, my lord, it was withdrawn.
Can
4
5
was wrongly filed, it was withdrawn by me. Can 5 is the setting aside of abatement, and Can 6 is the condonation of delay regarding filing.
substitution. As regards to substitution,
Pleadings are complete, your lordship.
It's section 5 application. In respect of substitution application. I am opposing.
Well, lord, matter is already fixed on 14.
Yes,
Your
sir.
lordship-
I
your
have
lordship-
seen that in the earlier August.
Your lordship has kept the matter on 14.
40. But the matter should appear under the heading application.
Yes, ma'am.
item number?
Item 21, ma'am.
Yes, 21.
Your lordship sees the last order.
So let the matter appear under the same heading on the other side of the ensuing puja holidays on 14th of November 2024.
It should appear under the heading here, application. Because it is not hearing.
Then it will come up on 14th only.
14th, under the heading application.
It is hearing আসবে তো? Hearing আসবে না। Application গুলো pending আছে না? যেগুলো তো under the heading application আছে, ঠিক আছে? Hearing আসবে না। তাহলে No. As because the record is to come up on 14th. Somehow it has not been mentioned in the cause list শুনুন তাহলে শুনুন এখানে তো তিনটে সেটা তো 1 2 3 আজকে যেটা আর্গুমেন্ট হলো ওটা 4 নম্বর এইবার যা যা ঠিক আছে ঠিক নে serve means suit for in 22 the appellant the appellants are being represented but none is representing the respondents full stop as the respondents are not being represented so the matter could not be proceeded with let the matter appear on 14th 14th next Friday
number 23
23, my lord, Mr. Shukanta Chakraborty is appearing on behalf of the appellant. My lord will kindly keep it next week, my lord, and for not today.
My lords, I'm for the respondent 2 and 3. I have an innocuous prayer. There have been multiple directions to serve us the cause papers. We have received nothing. Last 2024's order, July, my lords, has specifically recorded again to serve us papers. Till date, we have not received anything.
order of 10th of July not 25 24 any order is required
No, my lord,
It's kindly direct because we have tried a number of times. Neither the client, neither the advocate on record has received anything. Just like I plead for the last time. I'll try again. Convey a letter to
as
the
regards to the other respondents
respondent 1 has received, that is recorded in that order. I am a pro forma respondent. I have not received till date 2 and 3.
the appellant the learned counsel representing the pro forma respondents number 2 and 3 submits that in spite of several requests, the copy of the memorandum of appeal has not been served upon either the respondents or the learned counsel representing the respondents. Full stop. Paragraph. On perusal of the order dated 10/7/2024, it transpires that by the said order, the appellant, the appellants were directed, the learned counsel representing the appellants was directed to serve copy of the memorandum of appeal, but in spite of passage of more than 1 year, the said copy of the memorandum of appeal has not yet been served. Paragraph. The learned counsel representing the appellants is once again directed to serve copy of the memorandum of appeal upon the learned counsel representing the respondents number 2 and 3 positively within
Or within next week, Madam.
within November. Within 12th of November, that is Wednesday, within 12th of November 2025. Let the matter appear on 14th.
Much obliged.
Item number 24.
22, my lord. This is my appeal, my lord.
My lord, I am for the respondent number 1. Before we begin, just one point I want to say that the appellant has died and the appellant's brother, respondent number 2 has also died. Now they have filed one substitution application for substituting name of the appellant with the heirs. But our point is that the respondent number 2, who is the appellant's brother, he is also co-landlord. He should also be substituted. But they have filed an application for exemption from substituting the respondent number 2's legal heirs. That I have made objection. At this stage, this case is filing because we had recognized respondent number 2 as landlord, but appellant is saying he's the landlord, he's the brother of respondent number 2.
Lordship, there was a direction for affidavits. My learned senior friend has filed the affidavit in opposition, to which we had filed the reply also. To the can number 3, that is the exemption from the substituting the respondent number 2, the pro forma. I'll rather say the pro forma, who did not appear at the time of hearing before the trial court, my lord. Mr. Ghosh on the last occasion had shown some provisions from the CPC, my lord.
যেমন ধরুন এটা N3 এর affidavit in opposition, ঠিক আছে? N3 affidavit, এটা কিন্তু এই N3 যেখানে আছে, এর সঙ্গে থাকবে ক্যান 3 affidavit হলো supplementary affidavit transfer affidavit in opposition আর হচ্ছে affidavit in reply মানে ক্যানটা পুরো সেট থাকবে ক্যানে ট্রান্সলেটরের মধ্যে আর এরা এখানে সেখানে যেন ইনসার্ট করে না দেয় in yes, what have you mentioned in the application?
My lord is taking up can 3 or my lord is taking up can 4, my lord. Can 3, in can 3, my lord, I have prayed for a dispensation from the substitution of pro forma respondent number 2, my lord. Pro forma respondent number 2.
Suit for?
My lord, suit for eviction, my lord.
Suit for eviction.
Eviction. This is primarily arising from an order of remand from the first court of appeal.
Yes, whatever may be.
Yes, my lord.
The fact is that you and your brother are the landlords.
My lord, that I'll address it on a point, another point. But the thing is that, my lord,
Whether this person who has required,
the pro forma respondent number 2, my
what
lord,
is the name of the person?
Deepak Kumar Banerjee.
Deepak Kumar Banerjee. Deepak Kumar Banerjee is the brother of
Dilip Kumar Banerjee.
Dilip Kumar Banerjee.
My lord, kindly notes one thing, my lord. Deepak Kumar Banerjee did not appear before the court of law, learned trial court, nor in the appellate court, first appellate court.
Swapon Kumar Banerjee?
Swapon Kumar Banerjee has expired, my lord, long back. There are other legal heirs also. And my lord, there were odd.
Did Swapon Kumar Banerjee
No,
appear?
none of the pro forma respondents appeared, my lord. Neither in the trial court, neither in the first appellate court.
There are 3 landlords in respect of the suit property. There were Dilip Banerjee, Deepak Kumar Banerjee, and Swapon Kumar Banerjee. On the death of Swapon Kumar Banerjee, he has been substituted by his wife and a daughter and a son. There is more landlords.
My lord, there were
Dilip Kumar Banerjee and Lotika Banerjee. Lotika Banerjee is since deceased. Mohit.
Substitute.
There were
who was Mohit Kumar Banerjee? Mohit Kumar Banerjee. Who was Mohit Kumar Banerjee?
Mohit,
the original landlord. He was the original.
He's the father of
your father.
Father of the appellant, my lord. My lord, there are orders from this court, my lord. There were the services were dispensed of in respect of certain pro forma respondents, my lord, by the predecessor, my lord.
The suit property belonged to
the plaintiff.
Told only the plaintiff.
No, not only the plaintiff.
There were, my lord, Lord, if I may, if this query, my lord, if I may come back on the next day, before that, my lord, the substitution of the appellant may be allowed. He is the sole appellant, my lord. Unless and unless he is substituted, my lord, I cannot proceed with the appeal, my lord.
That will be taken care of later on. First, you give a reply to this one.
My lord, I'll come back on the latest next day, my lord. Kindly fixes a short date. I'll come back and I'll address.
And as regards to substitution of Dilip Kumar Banerjee,
That I have no objection, but the
and 4.
Can 4, that is my can 4. Sole appellant, my lord. The legal errors are at page 4, paragraph number 2, my lord.
You are the sole tenant or the
so sole tenant.
There are several.
No, there are many other tenants, but in this case, I am the tenant.
Other was the
In this case, I am the sole tenant.
You don't have any brothers and sisters.
No, I'm only there.
Can 4 দেখতে পাচ্ছি না। দেখুন can 4 of
2025, my lord.
25. Can 4 of 2025. Where have you filed?
My lord,
When and where?
my lord, I had during the it was supposed to be filed before the registrar administration
department.
Yes, because it is on time, my lord. It is on time. It is appearing as before your lordship. একবার লিস্টটা দেখতো। It's there. It's tagged along with the file, my lord. It's showing from the cost list.
এখানে রেখে দেন সিপ করে রাখেন অনেক সময় রেখে দেন দেখে আছে কিনা অনেক সময় অ্যাপ্লিকেশন গুলো আসে আলমারিতে রেখে আলমারি দেখতে হবে বাইরে থাকবে
$160 of the transfer of property.
রেজিস্টারের নোট থাকবে রেজিস্টারের নোট থাকবে রেজিস্টারের নোট থাকবে যে অ্যাপ্লিকেশন পেয়েছিল পাইনি
Sorry. No, wait.
তোমার অ্যাপ্লিকেশন আছে ঠিক ওখানে রেখে দাও ঠিক আছে দেখে নেবেন হ্যাঁ দেখুন বলছেন ঠিক অ্যাপ্লিকেশন এলে না আপনি এখানে রাখবেন মানে অভ্যেস আছে ওখানে রেখে দাও সবসময় এলেই সবসময় ট্যাগ করবেন Lord Counsel, the
Yes,
said
ma'am.
application is not tagged with the file. It has to be traced and tagged with the file. Nil. The learned counsel representing the appellant, representing the appellant submits that Dilip Banerjee, the appellant, has expired
on 27th of December 2024.
Has expired on 27th of December 2024. And an application being Can 4 of 2024.
25, my lord. 2025.
4 of 2025 has been filed seeking substitution of the said appellant. Mr. Paragraph. The said application being Can 4 of 2025 is not found in the record. Full stop. Let the said application be pressed and tagged with the file. Full stop. Let the matter appear on 14th of November.
I'll satisfy your lordship's queries relating what has my learned senior friend has alleged. That what about the ownership and all everything. I'll satisfy your lordship on that.
At the time of hearing of Can 3 of 2024.
Very well, madam.
Yes.
My lord, if your lordship remembers,
now you don't have the strength to represent anybody.
Lord, my strength is in Can 4.
Let the
my strength is in
let the Can 4 be allowed.
Yes, madam.
Much obliged, man.
Grateful, madam.
Item number 25.
For the appellant.
Yes, my lord. I am for the appellant, my lord.
Your adversary.
My lord, paper book is ready, my lord. Ready for hearing, my lord.
Everything is ready. No application pending.
No application pending.
Suit for
eviction.
Suit for eviction. You are the.
My lord, I am the landlord. I am the plaintiff and appellant. My lord, trial court decreed the suit. First appellate court reverse the same.
Why? On what ground it was decreed?
My lord, it was decreed. My lord, Lordship Valley 3, page 31. My lord, my appeal was allowed.
I'm not going into the record in the absence of the other side. On what ground? The suit was decreed.
My lord, that is, my lord, another that my lord, suit, my lord, is covered under the my lord, Transfer of Property Act.
Achha.
But my lord, appellate court held, my lord,
MOP.
My lord, because my lord, property is within the Panchayat area.
Achha.
Panchayat area, but appellate court, first appellate court held, my lord, that my lord, suit property is under the provision, would be covered under the provisions of West Bengal Premises Tenancy Act. And my lord, at page 31, my lord, my appeal was admitted, my lord, on 2 grounds.
What are the 2 grounds?
My lord,
Substantial questions of law.
Yes, my lord, whether the learned judge in the lower appellate court substantially erred in law in not considering the exhibit 2, which shows that the property in suit governs under the Transfer of Property Act. Because my lord, first appellate court held that property is under the governs under the provisions of
West Bengal Premises Tenancy Act.
West Bengal Premises Tenancy Act. But my lord, admittedly, my lord, suit property is within the jurisdiction of Panchayat area. And my lord, second ground, my lord, whether the learned judge in the lower appellate court substantially erred in law in relying upon the order passed in the application filed under section 17(2)(2)(a) of the West Bengal Premises Tenancy Act, holding inter alia that the defendants are the premises tenant under the plaintiff, disregarding the fact that during the evidence it was established that the property in suit is in the Panchayat area. Well, in the evidence, well, they have admitted that well, property is within the Panchayat area.
17(2) and 17(2)(a) reflects otherwise.
Yes, my lord. But my lord, first appellate court held, my lord, that ground, my lord. And my lord, reverse the decree. May I?
Trial court record এসছে, trial court record, first appellate court record এসছে তো?
Paperwork ready, my lord. Paperwork file. Yes, paperwork ready.
Trial court record and the first appellate court record is there. Record of the trial court and the first appellate court is there.
My lord, paperwork is ready, my lord. On the last occasion, my lord, Lordship was pleased to pass order that, my lord, on the last occasion.
If there is unavailability of the trial court record and the first appellate court record, then you couldn't have prepared the paper.
Yes, yes, that is why. Yes.
You have prepared the paper.
Yes, yes. Because my lord, Lordship's direction was there, my lord. My lord, Lordship, my lord, on 24th April 2024, my lord. The learned counsel submit that the record of the trial court and the first appellate court have been received by the honorable court. Yes, my lord. And that's why, my lord, direction to file paperwork was passed.
Prior to commencement of the hearing, be kind enough to go through the entire record, including the exhibited documents. The appellant is being represented. The appellant is being represented, but none is representing the respondents. Full stop. In such circumstance, the learned counsel representing the appellant is directed to intimate the learned counsel representing the respondents that the matter will be taken up for hearing on 14th of November. Let the matter appear on court.
Item number 27.
None is representing either the appellants or the respondents. From the next day, that is, this bench will be available on Fridays. No adjournments will be granted, and necessary orders will be passed. This is for in general.
One thing before your lordship's rising, my lord, on 26th the day of September, one matter appeared.
28 ডেকে দিন 28টা ডেকে দিন আছে তো ডেকে দিন
Item number 28.
রেসপন্ড করেই দেব
এটা সেম অর্ডার হবে ঠিক আছে
My lord, I am appearing for appellant.
28
Huh.
Why didn't you respond? Appearing for
Appellant side.
appellant.
My lord, I am praying for a note.
This is the last time you can seek adjournment. Convey to your learned senior. ওনার নামটা নিয়ে নেবেন. Provide your name only. Learned advocate representing the appellant seeks an accommodation for this day. Full stop. None is representing the respondent. Respondent. Full stop. Let the matter appear on 14th. Yes.
27 February. 14.
27 of 14. Yes, Learned Counsel.
My lord,
Item number?
On matter has not been listed. On 26th, matter appeared before your lordships. Stew. your lordship having determination to take up the matter irrespective of the years. So this matter on 26, my lord, the matter appeared before your lordship, CO 1513 of 2024. Since the petitioner, I am the opposite party, I am suffering blanket order of stay. Since the petitioner is not appearing, your lordship directed me to intimate the learned advocate or the petitioner so that matter will appear 1 week after reopening. So 1 week after reopening is, my lord, today. My lord, I have already intimated the learned advocate of the petitioner.
Why the matter is not in the list?
Not appearing. It is supposed to appear today. এটা একটু দেখুন তো 26 তারিখে অর্ডার ছিল জজ সাহেবের। এটা 1 week after reopening এটা আসার কথা ছিল।
দেখে নেবেন ওটা কেউ যদি অর্ডার শিট থাকে কিছু তাহলে সেই অনুযায়ী অর্ডার শিট অনুযায়ী ফলো করবে।
আমি already communicated that নাম্বারটা লিখে দেবো নাকি আপনার? বড় স্লিপ আছে, ছোট স্লিপ এখানে আছে। My lord.
Do not see any other thing than
Other than readiness.